Let's talk about a special issue with respect to fiduciary duties in the partnership, namely the fiduciary duty of good faith one partner owes to another partner. Naturally, a partner owes a fiduciary duty of good faith to the partnership, but a partner also owes a fiduciary duty of good faith to her co-partners. Delineating this duty of good faith is a little bit difficult, so let's try and do that now. Now, let's just talk for a second about fiduciary duties in the corporation. Remember when we talked about fiduciary duties in the corporation, we never talked about fiduciary duties of one shareholder to another, and that's generally because we don't look at shareholders as having a fiduciary duty to the corporation or to another shareholder. We did talk about the fiduciary duties of the controlling shareholder, but we never talked about the fiduciary duty of one run-of-the-mill everyday shareholder to another. When we go into Chapter 7 and we'll talk about closely held businesses and we'll talk about the closely held corporation, we'll discuss whether there is some sort of higher duty of good faith between the shareholders of a closely held corporation. For now, let's introduce the issue by talking about the fiduciary duty of good faith one partner owes to another. Let's look at two transactions to start with. So in our first transaction, partner A is buying partner B's house. Partner A and partner B, they're partners in a partnership, and partner A is buying partner B's house. In the second example, partner A is buying partner B's partnership interest. In which of these transactions would partner A have a fiduciary duty of good faith to partner B? And the answer is in the second one, in the situation where partner A is buying partner B's partnership interest. Why? Because the buying of the partnership interest involves a partnership matter. And as far as the law is concerned, in this type of transaction, partner A owes partner B a fiduciary duty of good faith. And in a second, we'll talk about what that means. But for now, let's talk about the first example. Partner A is buying partner B's house. In this situation, partner A would not have a fiduciary duty to partner B. And of course, partner B would not have a fiduciary duty to partner A. When they are negotiating this transaction, the regular rules of contract negotiation apply. What does that mean? Well, that means you don't have to give up any informational advantage you have. You can hold on to your informational advantage. So if I'm partner A and I know that a developer wants to buy partner B's home for a large amount of money, and partner B doesn't know this, I would not have to disclose this to partner B. I can keep this informational advantage. And when I'm negotiating the purchase price, partner B doesn't know her house is worth a lot more money, but I do, and therefore I can gain an advantage over her in this contract. This is allowed under the general rules of contract law, contract negotiation. Same for partner B. If partner B knows something about her house that partner A does not know, generally partner B does not have to disclose this information. It's up to partner A to find out this information on her own. So partner B can have an informational advantage over partner A in this type of arm's length transaction. In the second example, where it involves the purchase of the partnership interest, this is partnership in business. This is a partnership matter, and we expect that partner A and partner B would deal with each other on a level that is different from regular contract negotiating. We would expect that partner A would disclose all material information she has about the partnership and the partnership interest that B would find relevant, and B would have to do the same thing. So in these circumstances where one partner owes a fiduciary duty to the other partner, there has to be some sort of exchange of information so that neither partner has an informational advantage over the other. All right, let's look at a couple other examples of where fiduciary duties of partners to one another will come into play. And generally what you're looking for is some sort of fact pattern that involves the exercise of control or discretion by one or more of the partners and a freeze out of the aggrieved partner. The aggrieved partner is effectively saying, you guys exercised control or discretion, and in so doing, you freezed me out of my reasonable expectations of my partnership interest. What are my reasonable expectations? Control and my economic interest. Here's an example. Let's say that in this partnership, based on the partnership agreement, partners vote on annual bonuses for each other. In our particular fact pattern, partner A has the controlling vote pursuant to the partnership agreement. Now, when partner A is voting on whether partner B should receive a bonus and what size bonus partner B should receive, partner A knows that partner B is in financial difficulty and needs a large bonus to pay impending debts. Partner A votes for a low bonus to partner B in an attempt to cause partner B to sell off her partnership interest so that partner B will be able to pay her debts. So we have an exercise of control or discretion on the part of partner A, right? Low bonus, I'm going to vote for a low bonus for partner B. Partner A's motivation was to cause partner B to sell out her partnership interest at a low price. You put this kind of economic pressure on her and she'll be forced to sell out at a low price. If you're selling out, if partner B is selling out her partnership interest at a low price, that means she is being frozen out of the reasonable economic expectation of her partnership interest. Remember, the value of her partnership interest is based on the future earnings of the partnership. Remember when we did valuation, we talked about the valuation of any business is based on the potential future earnings of the business discounted back to present value. If you give me a fair market value for my shares, you haven't frozen me out of the future profits, because it is the future profits discounted back to present value. That is the fair market value. But if you buy me out at a low price, then you are freezing me out of my share of the future profits of the partnership. In this case, I'm not saying that a court would necessarily say that partner A has violated her fiduciary duty of good faith to partner B, but I think there is a strong argument that partner A has done so. We will once again revisit this issue when we talk about fiduciary duties in the closely held business. We'll talk about the closely held corporation, closely held LLC, and we'll once again remind ourselves about what we learned about the partnership, which is the paradigm of the closely held business.